I'm David Miller, and I've been practicing estate and elder law in Texas for over 18 years now. You learn a lot in nearly 2 decades about the law, sure, but more about people, about what greed can do to families, about the silent suffering of the vulnerable, and the lengths some individuals will go to for a dollar. I thought I'd seen it all, but then Sarah Jenkins walked into my Houston office that crisp February morning. Her eyes were red-rimmed, her shoulders slumped, and she carried a thick manila folder that looked heavy enough to hold a lifetime of regret. She sat across from me, her hands clasped so tightly I could see the white of her knuckles. She told me her mother, Eleanor Vance, an 87-year-old retired school principal, had passed away peacefully in her sleep just a month prior. A natural death, a life well lived. But the peace ended there. Sarah explained that the family had just received a copy of Eleanor's final will. It was signed just 2 months before her death, and it completely disinherited Sarah and her 2 siblings, leaving almost Eleanor's entire multi-million-dollar estate, every penny of it, to her live-in caretaker, a woman named Brenda Hayes. My stomach dropped. Eleanor Vance, a woman known for her meticulous planning and fierce devotion to her children, suddenly cutting them out entirely. It screamed foul play. This wasn't just about money, it was about dignity, about legacy, and about the justice Eleanor deserved. We were looking at an estate worth close to $4. $5 million gone from a loving family to a predatory opportunist. The stakes couldn't have been higher. Here's what you need to understand about the legal framework governing cases like this in Texas. When someone dies, their will is presumed valid. To challenge it, you have to prove certain specific legal defects. In this situation, the 2 main legal avenues we explored were lack of testamentary capacity and undue influence. Under the Texas Estates Code, Paragraph 254, Y01, for a will to be valid, the testator, the person making the will, must be of sound mind when they sign it. This means they must understand they are signing a document that disposes of their property upon their death, generally know the nature and extent of their property, and know the natural objects of their bounty, i.e., a. who their closest family members are. If Eleanor wasn't of sound mind when she signed that new will, it's invalid. Even if she had capacity, we also had to consider undue influence. This is a common law concept, not just a statute, that basically means someone used their power and position to substitute their own will for the free will of the testator. It involves showing that the testator was susceptible to influence, that the influencer had the opportunity and disposition to exercise such influence, and that the will reflects the influencer's desires rather than the testator's. These cases are notoriously difficult to prove because the alleged victim is no longer alive to testify. It's a battle of circumstantial evidence. But if we could prove either capacity issues or undue influence, Sarah and her siblings would get justice, and their mother's true wishes would be honored. Sarah Jenkins was my client, but in many ways the real client was her mother, Eleanor Vance. Eleanor had been a pillar of the Houston community, a retired elementary school principal who had poured her life into educating children and raising her own 3 kids. She was 87, recently widowed, and her health, while not critical, was certainly declining. She lived in a beautiful, sprawling home in West University Place, a neighborhood she'd called home for over 50 years. Eleanor was, by all accounts, a kind, trusting soul, perhaps too trusting. Her husband, George, had passed away in January 2022, leaving Eleanor emotionally vulnerable and physically in need of more assistance. That's when Brenda Hayes, a woman in her mid-40s, entered their lives. Brenda came highly recommended, or so she claimed, by a distant acquaintance. She presented herself as a compassionate, experienced live-in caretaker, and for the first few weeks, she seemed to be just that. But Sarah, an architect in her late 50s, noticed subtle shifts. Visits with her mother became harder to arrange, phone calls less frequent, and often cut short by Brenda claiming Eleanor needed rest or was indisposed. By May 2022, Sarah felt like Brenda was deliberately isolating her mother. Then came the financial changes. Sarah mentioned that her mother had always been meticulous with her finances, but suddenly there were new bank accounts, talk of investment opportunities Brenda was helping with, and a general air of secrecy. Sarah was worried sick, but her mother, when pressed, would simply say Brenda was a godsend and her only true friend, now that George was gone. Eleanor's will, a document she had updated consistently over the years, had always divided her estate equally among her 3 children. The idea of her changing it seemed unthinkable. The new will, signed in October 2022, just 2 months before Eleanor's death, was the final devastating blow. Sarah's emotional state was a raw mix of grief for her mother, anger at Brenda, and profound guilt for not intervening sooner. She desperately wanted to fight, not just for the money, but to clear her mother's name and expose Brenda for the predator she was. It was precisely that kind of deeply personal, high-stakes fight that made me take the case. Our investigation began immediately, and it was a deep dive into Eleanor's last year of life. We started by issuing subpoenas for Eleanor's complete medical records, including all prescriptions and doctor's notes from every medical provider she had seen. Concurrently, we subpoenaed bank statements from all of Eleanor's accounts, including any joint accounts, for the 2 years leading up to her death. We also requested phone records for Eleanor's landline and Brenda Hayes' known cell phone numbers. I hired a private investigator, a former police detective named Frank Ramirez, to look into Brenda's background. Frank had a reputation for digging up dirt where others found only clean surfaces. He also interviewed former neighbors and family friends who had interacted with Eleanor during Brenda's tenure. Building a case for undue influence is like assembling a puzzle where half the pieces are missing, and the person who saw the full picture is no longer around. We faced immediate resistance. Brenda's attorney, a notoriously aggressive litigator named Richard Thorne, fought every single subpoena, claiming privacy and harassment. Thorne was known for his scorched earth tactics, and I knew this would be a bruising battle. He portrayed Brenda as a saint, a devoted caregiver who had given Eleanor comfort in her final months. My team worked tirelessly. The bank statements started revealing a pattern: large cash withdrawals, often made by Brenda with Eleanor's debit card, some labeled as reimbursements, but lacking any receipts. We also found several transfers totaling over $150,000 from Eleanor's checking account into a new joint account with Brenda, followed by swift withdrawals from that joint account into Brenda's personal funds. This started just weeks after Brenda moved in. The phone records showed a dramatic decrease in calls between Eleanor and her children after May 2022, and a spike in calls between Brenda and an attorney named Marcus Thompson, who, coincidentally, was the very lawyer who drafted the October 2022 will. We also found records of calls from Brenda's phone to Eleanor's bank on several occasions, around the time the joint accounts were opened and large transfers made. But the most crucial piece of the puzzle came from Eleanor's medical records. After a months-long fight, we finally got the complete file from Dr. Aris, Eleanor's primary care physician. Tucked away in that file, amidst routine checkups and medication logs, were notes from a neurological consultation Eleanor had in early September 2022. The specialist's notes confirmed a diagnosis of mild cognitive impairment, which wasn't unusual for someone Eleanor's age, but also specifically documented significant decline in executive function and memory, requiring full-time care and assistance with all financial decisions. This was just a month before the new will was signed. Frank, our PI, delivered another crucial piece of information. Brenda Hayes had been the subject of similar allegations in Florida and North Carolina, involving elderly clients whose wills were mysteriously changed in her favor. Those cases settled out of court, but the pattern was undeniable. The real breakthrough, the moment my heart raced and I knew we had Brenda cornered, came with a second, even more detailed set of medical records from Dr. Aris that we had to fight tooth and nail for. We had seen the initial notes on mild cognitive impairment, but after a court order finally forced Dr. Aris's office to produce all records, including internal consultations and detailed nurses' observations, we found it. Tucked within a series of notes from late September 2022, just a week before that new will was signed, was an entry by Dr. Aris himself. It stated Eleanor was disoriented during today's visit, confused about her current living situation, and critically, demonstrated significant difficulty recalling details of her assets, repeatedly asking about bank accounts that no longer existed and expressing confusion about large sums of money. There was also a nurse's follow-up note stating, patient unable to articulate wishes regarding future financial management, defers completely to Ms. Hayes. I remember the exact moment I read that. I was in my office, late on a Friday, the fluorescent lights humming overhead. The pages felt cold in my hands, but my mind was on fire. This wasn't just mild cognitive impairment. This was clear, documented evidence of profound confusion and a lack of understanding about her own estate, precisely when she was supposedly making a monumental decision to change her will. It directly contradicted any notion that she possessed the testamentary capacity to knowingly and freely sign a new will. It was the smoking gun. It showed Eleanor couldn't possibly have understood the nature and extent of her property, let alone her decision to disinherit her children. When I called Sarah and read her those specific entries, she didn't just cry, she sobbed, a mix of relief that her mother's suffering was documented and renewed anger at the woman who had exploited her. "She really didn't know, did she, David?" Sarah whispered, her voice choked with emotion. "She really didn't understand what she was doing." No, she didn't, and now we had the proof. The courtroom drama unfolded in the stately Harris County Probate Court, presided over by Judge Emily Chen, a stern but fair woman with an unwavering gaze. The wood paneling, the quiet hum of the air conditioning, the low murmurs of the attorneys. It all created an atmosphere of tense anticipation. Our strategy was to methodically dismantle Brenda's facade, piece by piece. Our key witness was Dr. Lena Kahn, a highly respected geriatric psychologist I had retained. Dr. Kahn had reviewed Eleanor's complete medical history, including the crucial notes from Dr. Aris, and was prepared to offer her expert opinion on Eleanor's testamentary capacity at the time the will was signed. She explained in clear, concise language how Eleanor's documented cognitive decline, coupled with the heavy medication she was on, would have significantly impaired her ability to make complex financial decisions or truly comprehend the implications of disinheriting her children. She testified that the documented confusion about her assets was a clear indicator that Eleanor lacked the sound mind required by law. Richard Thorne, Brenda's counsel, conducted a brutal cross-examination, trying to paint Dr. Kahn as a biased, hired gun, and questioning the validity of her assessment since she had never personally examined Eleanor. He pressed her on Eleanor's good days, those moments when she might have appeared lucid, but Dr. Kahn stood firm, explaining that cognitive decline is often intermittent but progressive. And the medical records clearly showed a downward trend and specific moments of profound confusion directly relevant to the will's signing. Then came my cross-examination of Brenda Hayes. She had testified under oath that Eleanor was sharp as a tack, fully aware, and had meticulously planned the new will, claiming Eleanor felt her children were ungrateful and she wanted to reward Brenda for her selfless devotion. I began, calmly, building my case. "Ms. Hayes," I started, "you testified earlier that Mrs. Vance was perfectly lucid and understood every aspect of her new will, didn't you?" "That's correct," Brenda replied, her voice firm, almost defiant. "And you claim she meticulously planned this new will, leaving you millions?" "Yes, she did. She chose to, out of gratitude." Yet, Ms. Hayes, just 1 week before signing this document, Mrs. Vance's treating physician, Dr. Aris, noted she was disoriented and confused about her assets, repeatedly asking about bank accounts that no longer existed. "Are you suggesting, Dr. Aris was mistaken, or perhaps lying, Ms. Hayes?" I held up the medical report, its specific entry highlighted. Brenda's confident demeanor wavered. She looked at Thorne, who quickly objected. "Objection, speculation, calls for information the witness wouldn't know." Judge Chen, however, looked directly at Brenda. "Overruled. The witness testified to Mrs. Vance's lucidity. She can answer if she believes a medical professional's assessment was incorrect." Brenda stammered. I don't know what to say. She seemed fine to me." Her face was starting to drain of color. "Seemed fine, Miss Hayes? Or was she, as her doctor noted, unable to articulate wishes regarding future financial management and deferring completely to you?" I paused, letting the silence hang heavy. "And the lawyer who drafted this will, Mr. Marcus Thompson, he's a longtime friend of yours, isn't he, Ms. Hayes? You used to work for him as a paralegal, didn't you?" Another objection from Thorne. Objection, relevance. The credibility of the circumstances surrounding the will's drafting is highly relevant, Your Honor, I countered. Judge Chen sustained my point. Brenda's eyes darted around the courtroom. That was years ago. It has nothing to do with Mrs. Vance. Doesn't it, Miss Hayes? Our phone records show you calling Mr. Thompson's office repeatedly in September 2022, before Mrs. Vance allegedly made this independent decision to change her will. You arranged for her to meet with your friend, didn't you, not her long-standing estate attorney? Then I presented the bank statements. And 2 days after this will was signed, Ms. Hayes, a $50,000 withdrawal was made from Mrs. Vance's checking account, directly into a joint account you had recently opened with her, funds which you then promptly transferred into your personal savings. You claim this was a gift? Brenda was trapped. She sputtered. She wanted me to have it. She loved me. Thorne looked visibly defeated, his usual bluster gone. The courtroom went silent, the weight of the evidence crushing Brenda's every lie. It was devastating. Judge Chen's ruling came down about 3 months after the trial concluded. She issued a thorough, well-reasoned judgment finding that Eleanor Vance's October 2022 will was indeed invalid due to both a lack of testamentary capacity and egregious undue influence exerted by Brenda Hayes. The judge meticulously detailed the pattern of isolation, the significant financial transfers, Brenda's connection to the drafting attorney, and, most damningly, Dr. Harris's detailed medical records showing Eleanor's profound confusion about her assets and inability to make independent financial decisions just days before signing the will. It was a complete victory. Eleanor's previous will, which had left her entire estate to her 3 children in equal shares, was reinstated. This meant Sarah and her siblings inherited the roughly $5 million estate. Furthermore, Brenda Hayes was ordered to repay the $50,000 gift and any other funds she had unlawfully taken from Eleanor. Brenda's face, when the ruling was read, was a mask of disbelief, quickly followed by dark, simmering rage. Thorne simply packed his briefcase, a rare silence about him. Sarah, on the other hand, broke down in tears, burying her face in her brother's shoulder. They weren't just tears of financial relief. They were tears of profound justice for their mother, a validation that her true wishes had finally been heard. While Brenda eventually filed for bankruptcy to avoid the civil judgment, the evidence we uncovered also led to a subsequent criminal investigation by the district attorney's office, resulting in fraud and elder abuse charges against her. This case taught me, yet again, the insidious nature of elder abuse. It's not always obvious, a bruise or a broken bone. Often, it's a slow, methodical manipulation, hiding in plain sight, preying on loneliness and dependency. What I learned most profoundly is the critical importance of vigilance, not just for attorneys, but for families. Trust your gut. If something feels off, it probably is. The broader legal lesson here is that while proving undue influence or lack of capacity is incredibly challenging, because the victim is no longer able to speak, the law does provide avenues for justice. We have to be meticulous, to uncover every stone, every document, every witness, to piece together the truth. For viewers, the warning signs are crucial. If an elder is suddenly isolated from family and friends, if there are unexpected changes in their financial behavior, new joint accounts, or friends, or caregivers who seem overly involved in their personal and financial affairs, especially if there are sudden changes to their estate plan, these are all giant red flags. My practical advice is simple. Maintain regular contact with your elderly loved ones. Ask questions. Have their legal documents, especially powers of attorney and wills, reviewed periodically. And, if you suspect something, anything, act quickly. Consult an attorney specializing in elder law. The longer you wait, the harder it becomes to recover the evidence, and the more damage can be done. This case, like so many others, showed me the depths of human desperation and greed, but also the incredible resilience of a family fighting for what's right. Months later, Sarah and her siblings used a portion of their mother's estate to establish a foundation in Eleanor Vance's name, dedicated to combating elder abuse and providing resources for families navigating similar situations. They are still healing, but they are healing together, honoring their mother's memory with purpose. That's why I do this job. to fight for those who can't fight for themselves, to give a voice to the silenced, and to ensure that justice, even if it's painstakingly won, ultimately prevails. Drop your questions in the comments below, share your thoughts, and let me know if you've encountered similar situations. I've got plenty more stories to tell, so hit that subscribe button if you want to hear them.